Hello and welcome to the FHS Sutherland podcast on global freezing orders. In this episode, we will provide an overview of freezing orders in Hong Kong. My name is Jason Tam. I'm an of-counsel of the Litigation and Dispute Management team of FHS Sutherland Hong Kong.
And I'm Wing Chan, also an of-counsel of the Litigation and Dispute Management team in Hong Kong.
In Hong Kong, the court has the power to grant a freezing injunction, which is a form of relief that allows the assets of a respondent to be frozen, thereby preventing the respondent from removing the assets out of the jurisdiction before the court delivers a judgment at trial.
However, in practice, it is not that easy to obtain a freezing injunction in Hong Kong. The applicant will have to establish that, firstly, there is a good arguable case on a substantive claim against the respondent. Secondly, the respondent has assets within Hong Kong. Thirdly, the balance of convenience lies in favor of granting the freezing injunction. And fourthly, there is a real risk of dissipation of assets by the respondent. And a court will only grant a freezing injunction where it is just and convenient to do so, even if those aforementioned requirements are satisfied. Jason, could you walk us through the process of obtaining a freezing order in Hong Kong? And what are the practical considerations when making such an application?
Absolutely. The applicant would first have to make an application to the court by setting out in an affidavit the reasons for such application and the basis on which the relevant test, as you have just explained, has been met. An application can be made with or without notice to the respondent. Where it is made without notice, the applicant has a duty of full and frank disclosure, and there will be a return hearing later at which the respondent can challenge the order, assuming it is made. A freezing order can be sought at any stage of a proceeding, including prior to commencing the claim or following judgment to assist with enforcement.
And what if any claim is ultimately unsuccessful and the freezing order granted has caused loss and damage to the respondent?
In making a freezing order application, the applicant would have to provide a cross-undertaking and damages to the respondent, which in some senses can be ordered to be backed by security as well. Wayne, can you talk about what are the assets that can be covered by a freezing order?
Generally, all types of assets can be covered. That includes any tangible or intangible assets, provided that they are not perishable, whether within the jurisdiction or outside.
To supplement, if the respondent has assets outside Hong Kong, the court can grant an order to freeze assets both within and outside Hong Kong by virtue of a worldwide freezing order.
That's a really good point. And from the perspective of the third party, usually a financial institution, what are the notification process to be expected once the order is granted?
The applicant will typically notify third parties of the freezing order where they might hold the respondent's assets. Indeed, if the applicant is concerned about disposition of assets, the applicant may well have notified third parties that a freezing order is being applied for. Third parties should proceed cautiously from that point onwards. Turning to protection for third parties under such order, Wayne, can you share more about what protections there are typically?
Sure. First of all, a third party is not prevented from exercising any rights of set-off that arise prior to the third party is notified of the freezing order. And the third party does not need to inquire as to the application of any money withdrawn by the respondent if the withdrawal appears to be permitted by the freezing order. Additionally, and generally speaking, a freezing order only affects third parties within the jurisdiction.
And most importantly, in the event of a breach of a freezing order, the point to bear in mind is that a third party does not owe a duty of care to the applicant. Therefore, it would be critical to avoid any action or statement that could undermine this position. For instance, this might happen if a financial institution, instead of merely acknowledging receipt of the freezing order, goes further to confirm that they will effect the order or use similar wording.
I see. So what would be the consequences of breaching a freezing order?
A respondent who disobeys a freezing order may be held in contempt of court and may be imprisoned fined, or have their assets seized. On the other hand, the third party may only be in contempt of court where they knowingly help or permit the respondent to breach the terms of the order.
This shows the importance of seeking timely legal advice, especially you happen to be the subject of a freezing order.
Agreed. This brings us to the end of today's episode. Thank you very much to all of our listeners. We hope you find this episode insightful. If you have any questions, feel free to contact our litigation and dispute management team.
We also encourage you to look out for podcasts on other jurisdictions and visit our website and LinkedIn to stay tuned of other insight and legal developments. Thank you and goodbye.